eno ye Extreme Media UJ. Subscribe for all updates.
Had the ruling of court. We obviously do not agree with it. We find it to be a very problematic ruling. And you see, when court says that the media should be thrown out, they should have no access with their gadgets and so on, that matter began in Kawempe, very problematic. The same has happened here. It's not even good for court. I don't know who advises these courts, because when you tell journalists that you only enter with a piece of paper and a pen to write, don't enter with gadgets. What happens if this journalist does not clearly hear what the judicial officer has said or what the state prosecutor has said because they are scribbling away? And then they misquote you. Who will you blame? But when there is a recording, this journalist will go back to their newsroom, and what they didn't hear properly, they'll play back this recording so that they properly quote the judicial officer or the state prosecutor. But for some reason, they've decided to rule this way. I don't know where they get that from. Anyhow, the other ruling, of course, was not a ruling, but court was warning to say, yeah, the Subjudice rule does not allow journalists, us, and even lawyers to talk about the merits of this case. We know that, of course, as lawyers, but the Subjudice rule does not stop us from talking about political undertones and the situations happening in this country. It does not. For example, to say that this matter here is not a legal matter, it's a political matter. For us to demand and say that the people who were killed at Honorable Muwanga Kivumbi's home, we demand for justice for them. We shall not stop talking about these things. Asante.
Objection or issue, whatever they called it, seeking for orders of this honorable court to close out live streaming media from the proceedings of this honorable court. Well, we opposed the application because we thought it was really unconstitutional, especially if it's without any evidence of the threats that they were raising. The state's contention is that such orders were intended to protect ASP Bananywa, to protect AIP Akampulira, and Corporal Omota Julius, who were all police officers. So they sought an order to protect witnesses who are security witnesses sought to be secured by the court, and that order has been granted. Of course, in as much as we respect court, we have the right to disagree with the decision of court. Court has gone ahead to make gagging orders, not only against whom the orders that the state sought. It went outside the prayers made by the state and went ahead to gag counsel in this matter and all and sundry, the public at large. We thought this was outside the purview of this application. It was without basis that such orders, sweeping orders against counsel were made. Ours is simple. We are going to reject this decision through lawful means. Right from here, we are going to look for means of reviewing this decision in higher courts. This decision, though not of a court of record, is now setting a pace and a pattern. It started in Kawempe, Kanyanya, where grade 1 magistrate made the same orders. When we came into this application, they could not cite any decision of higher courts but that of the grade 1 in Kanyanya. How can that persuade this court? If you read the decision of Kanyanya and this one, they are similar in nature. So we believe it is unconstitutional, and courts should not close out the media. Closing out the media is closing out the public. Article 28 is very clear. The accused are entitled lead to a fair, speedy and public trial. So if you are to close out the public trial, it has to be with basis. So it is on those grounds that we are going to challenge this decision and reject it through the Uganda Law Society. Right from here, we are going directly to make a decision about this contemptible decision of this court. Well aware, if there are any threats, probably, it is caused by keeping the Honorable Muwanga Kivumbi here. Maybe through the bail application we made. That fear may be allayed by granting him bail. We are coming back here to court on the 3rd of September with a view to obtaining bail. What would stop this court from granting bail for a person who has bail from a specialized division of the High Court, the ICD?
Abalungi abatuuliriza era abatulaba olunaku olwaleero tukyaddeko ewa Sheikh Asiraf Dembe.
Sebo sanyusa okubalaba amannya agange Yezeseeka Asiraf Dembe akola ku bizibu by'enjawulo. Omuntu singa aba alina ebirwadde tumusomereddwa, tumuwa amazzi ga lukuya nga bw'obadde ogalaba, tugenda abantu ku kyoto ne twokya emizimu emibi egibabaamu n'okulomba edduwa. Abantu singa abeera ng'ali wano atuuse sobola okumulombera edduwa, ne waba atatuuse nga mpadde amannya ge naye ng'ali wala. Neetaase enamba yange yeno eri 0701763711. Namwe bannyinaffe abali ebweru oyagala okuba nti oyagala okulombera ku dduwa ng'olina ebizibu, viza zibuze, amaka gakolongotana, sente zikola zimpita mu ngalo, ojja kumpeereza ekifaananyi kyo n'amannya go, ebyo byokka bijja kummala. Nja kukulombera edduwa, ojja kutereera. Olunaku olusembayo mu mwezi mba n'edduwa eyawamu ffenna n'abalwadde bange abakadde n'abapya. Salaamu alaikum warahmatullahi wabarakatuh.